Hello everyone, welcome back to the YouTube channel Later Work CMA. In this video, we will start with chapter first of Business Laws and Ethics, that is Introduction to Law and the Legal System in India. This topic lays the foundation for understanding all other laws in your CMA syllabus. So, this chapter covers what is Constitution of India, preamble and its significance, sources of law, types of legislation, legal methods and procedures, alternative dispute resolution, and some of the terminologies. So, let's see the meaning of law. So, law is something, a set of rules enforced by a governing authority, and it regulates conduct of individuals and organizations, and it also ensures justice, order, and fairness. So basically, law is essentially a set of rules created and enforced by a governing authority such as the parliament or the courts. These rules regulate the conduct of individuals and organizations and aim to maintain justice, order, and fairness in a society. The next topic is sources of law in India, and there are two types of sources: primary sources and secondary sources. Primary sources of law includes Constitution of India, statutory laws, that is acts and legislations, and judicial decisions. And secondary sources of laws include customary law and delegated legislation. The next topic is the preamble, India's soul. The preamble is the introduction to the Constitution of India. It states the ideals, principles, and objectives that the Constitution seeks to achieve. Let's see the key features of the preamble. We, the people of India. Constitution gets its authority from the people and not from any king or outside power, and it is sovereign. India is independent, not under control of any other country. Socialist, commitment to reduce inequality and work for social and economic justice. Secular, freedom of religion, the state does not favor any religion. Democratic, people elect their representatives through elections, and the last feature is republic, where the head of the state, that is president, is elected and not hereditary. Let's see the objectives. First one is justice, that is social, economical, and political justice. Second one is liberty, liberty of thought, expression, belief, faith, and worship. Third one is equality, equality of status and opportunity. Then the fourth and the last one is fraternity, means promoting brotherhood, unity, and dignity of the individual. The legal importance of preamble is that it guides in interpreting the Constitution, and it is not enforceable in courts, and this was recognized as part of the Constitution in Keshavananda Bharati case in 1973. The next topic is types of legislation, and there are two types of legislation: primary legislation and secondary or subordinate legislation. Primary legislation covers laws made by the parliament, and subordinate legislation means rules or regulations by authority under parent laws. The next topic is the legislative process in India, that is how a bill becomes a law. Let's understand step by step. First one is bill introduced in parliament. So here a bill is a draft proposal for a new law or an amendment to an existing law. In India, a bill can be introduced either in the Lok Sabha, that is the lower house, or the Rajya Sabha, the upper house. There are different types of bills like ordinary bills, money bills, and constitutional amendment bills. After this introduction, the bill is published and copies are circulated among members of parliament. The second step is discussion and approval by Lok Sabha and Rajya Sabha. Once introduced, the bill goes through several readings like first reading and second reading and third reading. First reading is the introduction and circulation. Second reading is the detailed discussion, debates and possibility of sending it to a parliamentary committee for review. And the third reading is all about the final discussion and voting. If the bill is passed in one house, it moves to the other, where the same process is repeated. Both houses must agree and pass the bill in identical form. The third step is the President's assent. After the both houses passes the bill, it goes to the President of India. The President can give assent, that is, it will become a law. Withhold assent, that means he can reject the bill. Also return the bill. Other than money bills, President returns the bill for consideration by Parliament. If Parliament passes it again, the President must give assent. The fourth step is becomes law or act. Once the President gives assent, the bill officially becomes an act of Parliament. It is then published in the official gazette and becomes enforceable as law across the country. The next topic is ADR or Alternative Dispute Resolution, and it means solving disputes outside of court. And there are four methods: arbitration, mediation, conciliation and negotiation. Let's see the benefits of ADR methods. This is cost effective, time saving, less formal, maintains confidentiality and promotes mutual understanding. Let's see each one of them in detail. First one is arbitration. Here, a neutral third party known as the arbitrator hears the dispute and passes a binding decision. This is common in commercial contracts and it is governed in India by the Arbitration and Conciliation Act 1996. This is private, confidential and usually faster than litigation. The second method is mediation. Here, a neutral person known as the mediator facilitates communication between two parties to help them reach a mutual agreement. Mediator does not impose a decision and it is often used in family, workplace and civil disputes. The third type of method is conciliation. That is similar to mediation, but the conciliar may suggest solutions to resolve the dispute. This is less formal than arbitration and it is recognized under section 62 to 81 of the Arbitration and Conciliation Act 1996, and this is common in industrial and labor disputes. The fourth method of ADR is negotiation, a voluntary, informal process where parties communicate directly to settle disputes and there is no third party involvement. Mostly cost effective and flexible form of ADR is this. And the last or the fifth method of ADR is Lok Adalat, that is People's Court. And it is established under the Legal Services Authority Act 1987 and it deals with pending cases and no appeals lies against Lok Adalat's decision. In this chapter, there are many important terminologies that you need to remember. These terms are very important because they are often asked in MCQ questions in exams. So instead of just reading them, we are going to learn them through MCQs right here on this channel. This way, it will be easier to understand and you will also get good practice for your exams. So stay tuned, keep practicing with us and don't forget to subscribe to the channel for more. Thank you once again.